I am a PA who has been practicing for about 16 years. I just completed my first medical malpractice lawsuit and won at trial. My supervising physician settled a few days prior to the trial, so I was left alone to defend my care. It was a grueling 3.5-year process that has changed me forever. Going through this long ordeal, I learned a lot about myself. This process cuts us to the core and makes us question who we are, our morals, our values, and our skills as a provider. As a PA, we have the added weight of worry, guilt, and shame that we have let our supervising physician down. After coming out on the other side of this, I have some words of wisdom I wish I had known at the beginning. First off, this is not about you or your care. It's all about money. If your legal team and the insurance company are willing to take this to trial, they believe in you and the care that you provided. Your coworkers know who you are and the care that you provide. This lawsuit doesn't change any of that. I also wish I would have learned earlier to treat this lawsuit as a job and not a personal attack. Your job is to be a great witness. It's a skill we can learn. Meet with your lawyer for as many prep sessions as you can. The sessions are exhausting, difficult, and at times soul-crushing, but they make you bulletproof on the witness stand, and you will be impossible to rattle. Even a quiet, reserved, shy personality type like me was able to learn the skills to stand up to the bully plaintiff's attorney and not let him warp or manipulate my truth about the care I provided. You are not a bad person or a bad provider, no matter how much the plaintiff's attorneys and their experts want you to believe it. So keep your chin up. Continue to remind yourself daily that this isn't personal, and most importantly, let the wonderful person and provider that everyone else knows is there shine through, whether you believe it's there during this difficult process or not. Trust your legal team along with the people you hold close, and ignore all the rest of the noise that goes along with this process.
It's Season 3, Episode 10 of the Doctors and Litigation, the L Word podcast. I'm your host, Gita Pensa. Welcome back, everyone. This month, we are focusing on the advanced practice provider in litigation, the APP relationship to the physician in litigation, and the independently practicing APP, and some of the pitfalls we should all be aware of when practicing together. To start with, though, let's talk about the story that you just heard by the PA in the opener. I'll call her Mary. Mary and I began corresponding after she enrolled in my LEAP course. LEAP is Litigation, Education, and Performance, and you can find more about it in the show notes. I'm very grateful to Mary for being willing to share some of her insights with you. She's a PA who was sued for malpractice and became the sole face of the whole shebang at trial as her supervising physician settled out prior to trial. It was incredibly stressful, of course, but she chose to continue on with courage and smarts to learn everything she could about the process. And I don't know if I have the right to say it, but I'm really proud of her, both for seeing it through and for sharing her voice, which will be a help to any APP going through this process now that hears it. As an aside, if you have a brief story or case or some words of wisdom to share, reach out to me via my website. We'll get you instructions on how to record your story, and we will share them anonymously unless you want otherwise. I hope to share as many voices as I can here on the podcast and in a newsletter I'm launching this fall, which you can sign up for on my website. What I know is that the more stories we share, the more we reduce the shame that shouldn't be associated with this process in the first place, and the more support and knowledge we give to others going through it who feel isolated in this process. The more we talk about it, the better we will all weather it together. I think many APPs operate under the assumption that doctors usually bear the brunt of litigation, and that is still largely true. But plaintiffs' attorneys are increasingly targeting APPs as well. Now, let me say from the outset that I don't want to offend anyone by my choice of terminology, and that is not my focus today. So when I say APP, for the purposes of this podcast, I mean non-physician medical clinicians such as nurse practitioners, CRNAs, certified nurse midwives, and PAs. I know you're not all the same, but the risks for you that we're going to talk about today are. So for the purposes of educating you, I'm going to use the blanket term APP today. This process is difficult and frightening, and most of us face it unprepared. Changing that is the whole purpose of this podcast and my work. Mary made the point about this being about money, and as you're finding out, this really is about business and a plaintiff's attorney who wants to enrich him or herself much more than it is about justice, fairness, or what you did or did not do to take care of your patient. It's about whether or not they get to take home 40% or more of whatever payment comes out of this process, and their only real job is to figure out how to extract money and to get that number as high as possible. It is not about you. I love that she said to look at this as a job. Learn how to be a great witness, even though it is work, even though it feels uncomfortable, and you actually do not want to. But do it. Learn what you need to learn. Do not go into this process flying solely on what you think you know. And do not let this process make you forget who you are and the good you do in this world and the love you have for your patients. And let your relationships sustain you. Let them in. Let them hold you up. And then go fight the good fight. I have coached many, many wonderful advanced practice providers in every category I named. It doesn't seem possible, but it seems you have had even less exposure and education around litigation as doctors. And yet, you will experience the same psychological impact as a good doctor as I've been describing over these 3 seasons. And as you heard, there is the added grief of sometimes feeling as though you've let others down or brought them into litigation with you. And there's the stress of what happens to that relationship after litigation is initiated. You deserve to learn about this, to learn what it's really about, to get good at it. And in so doing, transform your relationship to the stressor that once upon a time you couldn't even bring yourself to think about. So let's get started. To help us today, I have my guest, defense attorney Anthony Ablin. He is a highly skilled and experienced attorney whose practice areas include professional liability defense and hospital and medical law. He holds degrees in law, educational policy, and history and policy, and is a member of the Bar of the Commonwealth of Massachusetts and the United States District Court for the District of Massachusetts. He also teaches legal writing and appellate advocacy at New England Law in Boston. He has tons of experience defending physicians and advanced practice providers, and please welcome him to the podcast to share a little bit about what he knows with us. Anthony Ablin, thank you so much for coming to talk about this topic on the podcast. I've had so many requests to talk about the intersection between doctors and advanced practice providers and litigation. And also now more APPs are practicing independently and they've got their own concerns about being the target defendant. And thank you for coming here to talk about all of it.
Thank you so much for having me. Definitely a hot topic.
Tell us a little bit about yourself and how long you've been practicing malpractice defense, and just warm us up here.
Malpractice defense my entire career. The vast majority of my practice is devoted to defending medical professionals, including APPs. I've been probably about 20 years now getting up there doing this and have the great opportunity to do what I can for medical providers in one of the most stressful times of their lives, which is being involved in litigation. I mean, I tell most of them when I meet them for the first time, I understand that I'm like the angel of death, right? I walk in the room and the plants wilt around me. Nobody wants to see me and talk to me, but it's an important role that I really appreciate the opportunity to have.
It is an important role. Thank you for what you do. I'm not sure that any of you get the adequate thanks that you need from us as a whole until we're really in the stew. And then we're so happy to have people like you on our side. But let's get to our conversation today about advanced practice providers. I would like today to talk about medical malpractice concerns for these advanced practice providers, and including midwives, and for the doctors they work with. Now, I do know that in some states, APPs can practice independently, and we're going to get to some concerns about the independently practicing APP in just a second. But most scenarios still are where the APP is working under the quote unquote supervision. And I'm doing the quotes because that can vary a little bit depending on the setting and depending on the attending and the APP. And that degree of supervision can change. So I think the first question that I want to start with is, how common is it for an APP to be involved in a lawsuit? I think back in the day, we didn't hear about it as much, but my sense is that that number is going up. I certainly have APPs as clients who are getting ready to testify on their own behalves and the behalves of their team. What are you seeing in terms of trends?
The numbers are definitely going up. They parallel the track of how the role of APPs is growing, not just independently, but in their role as sort of dependent APPs. PAs, NPs, for example, take on such a now important and expansive role in so many institutions in taking over sort of the critical aspects of care. And with that comes the attendant risk of just in terms of the numbers. But I think you're right. I think traditionally there wasn't as much exposure. But as the role of the APP really grows, even without their own panel, the more board complaints, the more litigation they're facing.
And I will say, I've discussed this topic with many APPs over the years, and they get even less preparation for it than physicians do in their education.
That's not saying all that much.
Exactly. Not saying
Right.
much, but I think they come into it like even more, maybe with this feeling like it wasn't supposed to happen to APPs. And then it can be really shocking when it actually does. So doctors are often supervising APPs. What to you as an attorney does it mean for a physician to be supervising an APP? How is that going to get interpreted by the courts, by juries? What does that mean?
Well, that's a great question. What does the supervision look like in a particular circumstance? The supervision is limited to checking the chart, signing off on a note. But in the sort of traditional APP structure, I think juries are going to want to see an active supervision, a supervision that looks at every aspect of the care, not simply sort of crossing the T's and dotting the I's on the notes, which I think sometimes just by sheer numbers, that can be a characteristic aspect of the supervision. It's just making sure everything's cleaned up because you don't have time.
Well, that's really common. I mean, it was absolutely standard in our environment for the APPs to see lower acuity patients really without any supervision. And there was an attestation that we would just pop into the chart that said that we reviewed the chart, and depending on whether or not we were involved, there was a different little smart phrase that you could just pop in there. What I became aware of as time went by is that now with the audit trail, it will become apparent how much time you spent with that note. And I know that I would just scroll to the bottom and sign that thing a lot of times when they were really very straightforward complaints. I would be like, okay, it's a toe injury, et cetera, et cetera. Okay, yeah, I got to sign. And that would be it. And I would move on.
And it has a lot of parallels to the relationship between attending fellow and resident, too, in terms of the sort of sign off and supervision in that way.
We're going to get into that separately. Maybe you and I some other time,
Another
because
day.
There's a lot of other dynamics there when someone is
Right.
supposed to be your educator, and there's a lot of hard feelings around that sometimes. And so we have to think about this on two levels. We have to think about it in terms of when we're billing for services and what does it mean for us to have had this space time with the patient? What are we documenting? We want to make sure that we're never fraudulent in terms of how we're representing the relationship with the patient. But here I really am I want to think specifically about like, what does a jury think about supervision and how hard is it to defend when it doesn't seem like they got adequate supervision? So I think we're going to get into that in a second. But tell me about some of the themes that come up when an APP and a physician are involved in litigation. Is it often more about the PA didn't involve the physician adequately, like when we're talking about supervision, or are they getting named independently for things that they may have done wrong in somebody's eyes?
Well, it's both, but I think APP, the concept of sort of where that line of independent judgment is drawn ends up being the struggle every time in a case where an APP is named and where a supervisor is named. At what point does that independent judgment need to be sort of checked with the supervisor. I'm thinking about this. This is my plan. What do you think about that?
And in hindsight, is there a lot of you should have known to involve the doctor sooner?
That is definitely a criticism, is you should have known that this was beyond the scope of your scope of service, essentially. This is beyond what you should have been able to handle on your own, and you should have gotten someone more senior involved. You should have gotten your supervisor.
And of course, everything in hindsight adjudicated that way. Sometimes you don't know you're in it till you're in it. And then hopefully you go and get somebody important. And the APPs, honestly, I know they're walking this line where they work for us and with us for a reason, right? They're not supposed to be getting us for, every single patient. They're supposed to make the workloads a little lighter. And so it's very hard for them to walk this line between involving the physician for everything versus exercising some judgment on their part and kind of walking that line. And whenever you're walking a tightrope, sometimes you're going to fall on the wrong side of it. I find it interesting to think about how it is that you as a defense attorney talk about that with juries in terms of explaining that level of supervision.
Well, it's interesting and it's changing, right? With respect as APPs take on their own panels. So in different jurisdiction and different circumstances, you have very different ways that you think about how to explain and what the standard of care really applies for an APP in a circumstance where they're dependent versus independent. So for the purposes of this sort of dependent APP, the tightrope is, we'll just use a PA for an example. This PA is an experienced, thoughtful, well-educated, prepared clinician who is able to use their own clinical judgment to make certain determinations. Yet, they're in this position where they're bound to a supervisor. So you sort of hit the nail on the head. The challenge, I think, is really getting to a point where the jury understands that it is not purely dependent. The PA isn't a reporter. The PA is an actor. Sometimes you'll hear, why do people end up choosing to go with a physician extender if they have a choice on an independent context? Because they get more time. They feel like they have more of a chance to sort of take their time with a physician extender rather than a doctor. At least that's what you sort of hear from time to time from patients in these circumstances. It's just a very interesting sort of balance to say that, particularly in circumstances where they are still in the dependent sort of structure of supervision, they are the ones that can make the decisions. Yet they have the supervisor.
So that's the line that we have to walk. So now let me ask the elephant in the room question, which is, let's say we have a case where a PA or an NP was acting more or less independently, and then something went sideways. Either the physician never saw this patient and reviewed the chart later and the bad outcome was realized after the fact, or the physician gets involved very late and then perhaps like the train is already running and we're not getting off of these tracks. Physicians are often worried about being named personally as defendants when they are supervising care that was largely rendered by an APP. From your experience, what predicts whether or not that physician will also be named? And is it pretty much automatic when there's a supervising MD or DO to be named in this? Is that just basically what happens most of the time?
Oh, I think so. I think it's almost automatic. And that's, I think, the risk that is run by being a supervising physician, is the recognition that as a supervising physician, you are bound up with the APP in terms of what happens with that care. The vast majority of cases that I've had are ones where everyone is in lockstep.
Meaning that we just did this episode on finger pointing. And so people will have heard a little bit about the dangers of the circular firing squad where everybody's trying to cast blame everywhere else.
I prefer the shootout in the lifeboat.
Okay, you're right. Yeah.
I mean, there is always the risk of that. And I think that for most supervising physicians, they recognize by committing to supervise, the negative associated with that is that you rise and fall with that.
And sometimes that's a condition of employment. Like you're just not going to work in certain emergency departments unless you're willing to take on that responsibility and that risk.
But it's uncommon, from my perspective, to see a circumstance where there's sort of a difference in opinion as to whether or not sort of a course of care.
Okay.
in a supervising independent circumstance.
Do you see scenarios in which the supervising physician is named and the NP that largely rendered care is actually not named at all? And will that person typically get deposed or called as a witness, even if they're not named?
It certainly does happen. And when it does happen, usually counsel for the defense will want that testimony, will want to have a deposition so that they can get a sense of, this is what happened with respect to the care that was provided. I think there are circumstances where plaintiffs' counsel want to name everyone and do that so that they don't have any empty chairs that they think the defense might point to. It's not throwing anyone under the bus by any stretch, but if an advanced practitioner provided the care, you can sort of maintain the position that that care was good. That care met the standard of care, but it wasn't me. I support the care 100%, but me supporting the care is irrelevant because I didn't provide it.
Yeah, interesting. I mean, the way these things shake out sometimes, I always counsel people that don't ask for it to make sense to you and don't necessarily ask it to feel totally fair, but this is the situation that we have. And being able to defend your care, other people's care, this is a critical skill when the care was good.
And cold comfort for defense counsel to explain that.
Mm.
Doesn't make any sense. I always feel bad when I'm like, I'm sorry, this is the way it is.
This is the way it is. See, they'll know that coming in now because they'll have listened to this. So, you know what? It probably doesn't take the sting away as much as
No.
but at least it won't be the first time they heard about it.
Yeah, no, I don't think anything you can say really takes that sting. But the more people that talk about it, the better it is.
Correct. Okay. So what can we do in terms of our documentation? So let's think first about the physician who's working with the APP. Is there anything that we can include in our documentation about the supervision of an APP that would be helpful to us in retrospect in court or in litigation?
Well, typically, with any documentation, that goes for the supervising APP or not, it's always better to have something that is written in a narrative form that's not form text. If you're clicking the box that says, I reviewed the note, when plaintiff asks the questions at physician's deposition, it'll be like, you didn't put any free text in here. You just clicked a box.
I do that all day long.
I know. And that's the glory and the horror of electronic records, right? It makes things much more efficient. But at the same time, there's always more strength in being able to tell a jury that, yeah, no, I wrote that in. I wrote that myself.
Even when you're just reviewing a note, just like note is appropriate?
When you can. And the answer is always when you can.
If you are reviewing a note, then you're saying that you're reviewing the note. You may have a smart text or something, but you're indicating that I've reviewed this note and that I find it appropriate. Does it work the opposite way? Is there a way that we should be documenting that sort of shows that, I am supervising this thing at a distance, or do we just let that lie?
I think the idea that you're supervising it from a distance is there's the tightrope, right? It's where is and what is supervision from a distance? Is that really supervision? Is it not? That's the sort of explanation that you have to get a jury to understand. That it's okay to have that.
Well, I mean, the ugly truth of it is a lot of times it's about billing. That doesn't feel good.
No, and I think that is something that juries typically don't like to hear. They don't like to hear about billing issues.
No. Doesn't feel good for us either. That's not what we want to be talking about. But these are all the things that we keep in mind.
Also a very real and, realistic, that's the way the system has to operate. There's no way around it.
I mean, Medicare sets these rules and you better follow them.
Right. I mean, what are you supposed to do?
So one more question about the physician documenting about the APP care. Maybe it could just be something like care appropriate.
Well, I reviewed the care and I agree with the plan, the sort of typical language. Obviously, so long as you do review it and agree with the plan. And that's sort of why I had mentioned the attending piece too. Attending and resident. It's a critical way to show that you have direct involvement. You know what the plan is.
And it's better that agree with the plan is free text.
Always better.
Always better. All right. Well, that's a good point to put in our pockets. Okay. Now, how about the APP documenting? Is there a way that they can help themselves and the supervising physician in terms of their documentation?
A great way for that sort of documentation particularly in terms of if there has been direct communication with the supervisor, is to say, I spoke to Dr. Smith and he agreed with the plan. That PA's free text then sort of works in the same way. It insulates both the advanced practitioner and the supervisor in a way to sort of say, yeah, look, we did have a conversation about this patient. And it wasn't simply a paper shuffling. It was, this is an active participation by both providers. I think that's a very powerful tool.
And the more you can free text about it, the better, I guess.
Hey, I'm a big fan of free text. That's all I can say.
I will say, I'm just going to put out there that like my notes are mostly free text. I mean, I might not write a lot, but like I don't use a lot of templates. We're going to get into hopefully in the future some episodes about documentation. And I mean, there's good and bad about all of it, but like I also am a fan of free text. So I'm saying this, that the workload is just ridiculous. And so you really usually can't write a lot.
That's the other critical piece is obviously, there has to be realism associated with it as well. You can't free text everything.
Yeah.
It's just not possible.
Yes. And so just sort of knowing what you can do in that moment, just that little bit to add in there extra. I actually like to throw in the word reasonable. Like I agree with the PA, it's very reasonable plan or something. I mean, something that shows like I thought about it.
Lawyer's favorite word, reasonable.
Right. That's what this is all supposed to be about. Reasonableness. We'll talk about that another day too, I think.
We've got like 3 or 4 more of these we got to do now.
Okay. So can you just give us a few stories? Do you have any cases that you can talk about that would just illustrate this relationship between the PAs and APPs in litigation once it unfolds?
Oh, sure. I've had cases where there have been exceptionally well-documented notes. And I think your point about documentation is critical. Exceptionally well-documented notes that indicate sort of layers of the conversation between the supervisor and the APP that lay out, I spoke with Dr. Blank and Dr. Blank agreed with the plan, as I mentioned before. I've had very well-documented notes that don't mention that layer of exposure to the provider because there is only the sort of suggestion in the checkbox that a supervisor had played any role in the dependent circumstance. I think more and more we're getting to the point where more and more cases that I'm seeing are of where you have the independent APP who is being asked essentially to serve as a primary care physician for the purposes of the standard of care. And that, is becoming more of an interesting issue.
Let's move into that a little bit. I have a few questions about that too. And as I said, there are a number of APPs who listen to this podcast, and I think it's time to sort of speak directly to them. So in states where APPs can practice independently, what new malpractice risks are there for them that differ from the APPs that are under supervision? Are you seeing now APPs becoming the sole target defendant in these cases?
Yes. And I think the problem that you run into is this sort of blurred line between APP and practitioner. As I was sort of suggesting, becomes something like, for example, in a primary care setting, the primary care provider for a patient. What standard are they held to? Are they held to the standard of an advanced practitioner or to the primary provider themselves?
And that's sort of a theoretical question until like what has happened? Like what standard are they held to?
And the reality is that more and more the line has blurred to the point where it becomes more of a primary care function. The standard of care for an APP becomes no different than that of an independently practicing APP becomes no different than that of for example, a primary care provider. It's obviously different in different sort of categories when you're dealing with nurse midwives, for example, or CRNAs or whatever the case may be. But in that sort of primary care setting, for example, if I'm going to hire an expert to defend my physician's assistant in a primary care setting, and I don't hire a sort of primary care provider themselves or a PA, and instead hire a PA, what is the difference between the two in that setting? There is not a difference in the level of care that the PA is supposed to be providing that a primary care physician, MD, is not. So in that case, I wouldn't feel the need to differentiate between the two.
Okay, so you would bring in an MD or a DO, physician expert, to support the care of advanced practice provider.
Typically, I would.
Although I'm seeing a lot more people sort of advertising their expert witness credentials as PAs or NPs. Are they being used much?
Right. And I think because, that's the challenge, obviously, that the PAs face or the advanced practitioners face is being in a situation where they are essentially asked to become the primary provider and are treated no differently than a physician. But I think the standard is essentially the same.
That's important to know. So if you're going to be practicing independently, you are going to be held to the standard, most likely, of an independently practicing physician, even though your education, training. Now, I mean, that's part of what I was taught. Usually part of the standard care is like similar education, similar training. But really what the jury's going to see is like, hey, if you are in that role, you better know all the things that someone in that role historically has known.
I think that is the key issue right there. It's that what is the jury's expectation going to be? And how is a plaintiff's attorney going to attack it? They're going to say, you are the primary care provider for this patient. That is the standard. And you can nuance it one way or another, but that I think is a challenge.
And it's all going to be what that jury believes about what they deserve as somebody who is getting, their primary care from an independent provider. I imagine that they feel like they deserve having that same standard for anybody in that job.
Only in the circumstance, right, again, where it's independent.
That's what I'm talking. If you're independently
100%.
practicing, like that's what the
Yeah.
jury is going to think. One
Yeah.
would imagine.
Right.
Now, what are the biggest blind spots you see? Like, let's say you have an APP who has been practicing independently and now they're the target defendant in a case. Like, are there the same blind spots as doctors? Like, are there other things that you wish you could tell them?
I think more and more it's the same blind spots. And document, document, document. That's the critical element. Almost invariably in every case, whether it's primary provider or PA or NP or CNM or whatever, the plaintiff's attorney asks the question or makes an argument to the jury that if it doesn't appear in the document, it didn't exist. It didn't happen if it isn't written down.
They always say that, but we always have things that we can say back to that. But yes, you're right. The less we have to explain, the better. And the more like really supportive documentation that's in there, also the better. They fall into the same traps we do as in terms of EMR or the test results getting lost somewhere and never coming to our attention. I mean, we're all in that same boat of like having to use these tools that are totally imperfect and drive everybody crazy. And yet this is what we've got. It behooves all of them to understand that they are setting themselves up. We need it. We need primary care providers. We need doctors who are really good to supervise APP. Like we as doctors, we really need good APPs. Like we cannot do this all anymore. We all need each other.
That need is being borne out in every state and almost every institution, is how essential APPs are to the practice of medicine now.
A good APP is worth their weight in gold. I truly believe this. And I have worked with some superstars in my career. I mean, amazing that I would go to and say, like, you could take care of me. Like, I mean that.
And I hear that time and time again on the good side of these cases. I hear that from the supervising physician. My physician extender is the greatest thing that's ever happened to me.
One last question, sort of like ugly question. Nowadays, we are seeing some of these corporations that like to hire green APPs right out of school and staff maybe a clinic or an urgent care or whatever without any supervision. They're just like throwing them in there. Now, I learned so much after like residency even, right? But I learned them from other people that I worked with. They're like working in like siloed in these places. And let's say something bad happens. Their knowledge base is incomplete. They've been thrown into these situations just as a consequence of how this employer runs their institution very leanly and with new grads because they are cheaper. This is a model that we are seeing over and over. When something bad happens, who bears most of the liability in that situation? Is it the employer or is it that brand new grad?
I'm going to say the perfect lawyerly answer of it depends on the circumstances. What I would say is that there are going to be more and more circumstances where plaintiffs' attorneys try to make hay with the institution themselves for circumstances such as that. It is a risk that I think institutions need to take very seriously, that they will be held responsible in some way, shape, or form as they are in every case, for the training and experience of the providers that they place in various circumstances. Now, that said, the sort of other response to that is that APP is qualified, is able to, within the scope of their service, perform the service that they're doing. As to current regulations, board regulations, etc., they're appropriately licensed and they're appropriately able to provide care. I think no one wins in that circumstance. There are definitely a lot of risks and pitfalls there institutions need to be careful of.
Well, we've sort of skirted the surface of a lot of different issues here. I'm sure there are more conversations to be had. Certainly, we've got to talk more about residents and their attendings who were involved in litigation together. And we've
I'll see you next
identified
time.
a couple of other conversations we've got to have in the future. But I think this is a good place to wrap things up. Thank you so much for the advice you've given today. And I think that talking about this stuff makes us all more cognizant of what our risks are and actually also how to do our jobs better. So I appreciate it.
Well, thank you very much. And thanks again for having me.
Thank you again to Anthony Abelin for coming on and sharing his expertise. And thank you for listening, everyone. If you know a PA, NP, midwife, CRNA, or other advanced practitioner who might benefit from this conversation, please share it with them. If you have a story you'd like to tell, or if you're interested in signing up for the newsletter or the LEAP course, visit us at doctorsandlitigation.com. I will see you next time, and until then, keep doing good work and fighting the good fight.